if there's a coalition agreement by the parties and etc., that becomes a defense. So if you challenge and say, no, I haven't done it, we are obliged to hear you. Okay? Mm-hmm. But none of the MPs complained. How can you be crying more than the bereaved? They know what they have done. They were entitled to be in the House. When we raised the issue, they had 2 clear days because Speaker said, give me 2 days to ponder over the matter. Those 2 days, they could have gone to Speaker and said, Mr. Speaker, no, what they are alleging they have done, I haven't done. Because this was a matter of public knowledge, that this matter has been raised. One of them knows. Esiama, it happened to him in 2000. He was sacked from Parliament. He didn't attend Parliament. He went and contested and came back and even got rewarded, when there was... of course, when our seats were equal, MPP, NDC, and then they now went looking for him, they gave him Deputy Speaker, as consideration for him to join them and do business with them. So the whole question of not being heard doesn't arise because none of them is challenging it, none of them is complaining. Afenyamarkin is only fighting because he has lost his post as a majority leader, and so he's running everywhere and then cajoling, Supreme Court judges to do the unheard of things that is embarrassing the Supreme Court.
Well, Mr. Ayariga, I'll take you back to the issue about that Supreme Court ruling. Yes. I've heard you extensively mention, and others also mentioned, that the Supreme Court erred, others also disagreed. But if your intention is not to create chaos on Tuesday in Parliament with your insistence that you are indeed the majority in spite of that particular ruling, even though you've said that until the Speaker communicates to you and say you should jump, you only ask how high you should jump, why then are we not waiting for that rather than insisting that come Tuesday you are the majority and nothing will stop, even going ahead with some of the policies that you're hoping to correct? Well, is that not a chaotic move your side is making?
Well, disagreeing with a bad, unfounded communication from the Supreme Court, I don't see that. I don't see that.
It's a ruling. Unlike the Speaker's own, which was a communication. It was a ruling from the Supreme Court. People are. The Supreme Court asking Parliament to stay a decision. Okay, a directive.
It's not a ruling.
But you said it's a communication.
It's a directive. A communication coming from the Supreme Court to the Speaker to stay his action. Are you getting the situation? So that is a matter between the Supreme Court and the Speaker.
How can you say this is a matter between the Supreme Court and the Speaker?
Have you looked at what the Supreme Court has said?
Mr. Ayariga, the same communication from the Speaker that you are acting on to say you are the majority. Now there's a directive from the Supreme Court to the Speaker, and you are saying it's a matter between the Supreme Court and the Speaker. How can you say that?
Because those are the facts. The facts are that on Friday, the Supreme Court is said to have met and then said to have taken certain decisions, one of which is to say that they are suspending a decision of
the Speaker
in Parliament, properly constituted. That decision has not yet been communicated to the Speaker.
Yes.
If it is communicated
to the Speaker, by the judiciary and the Speaker agreement, it's supposed to be served on Monday.
If it is communicated to the Speaker, it is for the Speaker to say he accepts or he doesn't accept. And we are saying that as we sit here.
It's for the Speaker to say he accepts the Supreme Court's directive or not?
Yes, it's for him to say he accepts or he doesn't accept.
He's clothed with such powers.
And who says the Supreme Court is clothed with powers to intrude into the business of Parliament and suspend decisions of...
Even if it violates the Constitution, if the Speaker is set to make a decision.
Have they established that it violates the Constitution?
Exactly. So I'm asking you as a lawyer.
Have they established that it violates the Constitution?
But if we get to a point where the legislation is refusing to accept directives from the apex court of this land, where are we going? We are going back. You are restoring the law of nature in this country, where the strongest fights and wins. Is that where we want to get to as a country? You are the lawmakers. You should be setting the right example, is what people have said.
That is why you should have knowledgeable people in the Supreme Court. You should have people who know their law. Do you know why?
The Supreme Court is not made up of knowledgeable people.
If they were knowledgeable, they would have known that the U.S. Supreme Court, in the case of Baker and Carr in 1968, said that there are certain matters that are, by their nature, political matters within the domain of the legislature and the executive, those matters, the Supreme Court should run away from them. They should not get entangled in those matters. Because when they get entangled in those matters, there will be this type of clash.
Even
where the legislature, listen carefully, where the legislature will say one thing and then the Supreme Court will say another. Where the executive will say one thing and the Supreme Court will say another. That is what happened in the Salah case. In the Salah case where President Bouzier said no court can sit and direct him as to how he should run the affairs of this country. It's a similar circumstance. In Baker and Carr, the court enumerated a number of circumstances and showed that those circumstances are by their nature political, divisive. Is that okay? Controversial. They are matters that are within the domain of the legislature. The Supreme Court should run away from them. Don't get involved in those matters. Don't hear those matters. Leave the politicians to deal with their issues. This is a classic case of a situation where the legislature has done what clearly the language of the Constitution authorizes it to do. The Supreme Court, you hurriedly meet without giving the legislature hearing. You are talking about hearing. Did you give the legislature hearing?
It was an ex parte motion.
Did you?
It was an ex parte motion.
So that is the more reason why they should know that in controversial matters like this, let me hear the other side. In politically charged matters like this, let me tread cautiously. And so they shouldn't have, with the kind of haste, somebody files an application in the morning and by afternoon you're already meeting. When the chief imams, the pastors have been demonstrating and petitioning for the past 2 years that you should quickly sit on the issue of LGBTQ and then give them a decision, and you have been sleeping and snoring on your benches and not paying attention to them. All of a sudden somebody comes in the morning and by afternoon you are able to sit and give directives to the legislature. The point I'm making is that this is a classic case of what the Supreme Court of America, where we are learning our jurisprudence of Supreme Court from, said, Supreme Court, don't get involved in these matters. How can a Supreme Court be telling us that, oh, I have to injunct Parliament, I have to restrain them because one side has come to say that, oh, if you allow this situation to prevail, the business of government will be stopped. Is that your business? I have said this on other networks that it's not the business of the Supreme Court if the NDC in Parliament says that they are going to repeal e-levy. If the rules of the House and the processes in the House enable them to repeal, go and fight them in the House.
But the Supreme Court is not saying you should not repeal e-levy.
That is what they have.
That's not what the Supreme Court is asking at. But really,
Mr. Ayariga,
have you read
what they have said?
As a lawyer,
No,